for tonight's webinar, Bathrooms, Boundaries, and Your Child's Rights, the Legal Landscape of Title IX and Student Privacy, here focused on Wisconsin. My name is Scarlett Johnson, and I'm with Moms for Liberty. And Moms for Liberty is an organization dedicated to unifying, educating, and empowering parents to defend their parental rights at all levels of government. Tonight's conversation comes at a remarkable moment. It's been a very great week. Just last week, there was some major developments for parents across America and right here in Wisconsin. Last Monday, the United States Supreme Court handed down a major parental rights decision in Mirabelli v. Bonta. That case challenged California policies that allowed schools to facilitate gender transitions for students while keeping parents in the dark. In its ruling, the court made something very clear. It said the state's policies to cut out the primary protectors of children's best interest, i.e. their parents, was not constitutional, and we agree. So for many parents across the country, that statement captured what this debate has been about. Parents are not bystanders in their children's lives. They are their children's first protectors and primary decision makers. But it's important as that victory was, there are still many questions about the decision, what it means going forward, the future of Title IX, so many questions that we navigate every day and that I ask my friends who are here on this webinar on an almost daily basis. I am like, hey guys. So we thought it would be really great to have this webinar so that they could answer these questions for everyone, because I know that there's just a lot going on every day. It feels like there's something major dropping. Speaking of which, just last week, Thursday, the U.S. Department of Education Office of Civil Rights announced that it's opening a Title IX investigation into the new Richmond School District. That's a small rural district in Wisconsin bordering Minnesota. There were allegations that a biological boy was using the girls' bathroom, and those allegations were confirmed by the school district and the school board. And when parents came in droves, hundreds, to complain, and when the girls came to the board meeting and they said that they were uncomfortable, that they didn't want a boy in their bathroom, the school district basically told those folks to go pound sand. And the result was a major victory for us here in Wisconsin as this investigation was announced. So here we are tonight, and we're fortunate to be joined by two amazing attorneys who are deeply involved in these issues. First, Cece O'Leary, the Vice President of Legal Initiatives at the Southeastern Legal Foundation. Founded in 1976, the Southeastern Legal Foundation is the nation's oldest national conservative nonprofit law firm dedicated to defending liberty and restoring constitutional balance in our system of government. The Southeastern Legal Foundation has been at the forefront of legal challenges to government overreach and is proud to represent Moms for Liberty in cases defending parental rights and pushing back against radical gender ideology in schools. We're also joined by my friend Corey Brewer, an attorney right here in Wisconsin with the Wisconsin Institute for Law and Liberty, or WILL, as we like to call them. WILL has become one of the leading public interest law firms in Wisconsin and nationwide, defending constitutional freedoms, advancing education reform, and representing parents and students when their rights are violated. So thank you both for joining, and now I'm going to pass it to the lawyers.
Thanks, Scarlett. Thanks for that introduction. And you're right that this is a really timely discussion. We of course planned it in some ways because of everything that's going on in Wisconsin, but in other ways, yesterday was International Women's Day. We didn't plan it to be right after that, but this is certainly something that is important to all of us as we fight to protect women and girls across the country and boys who are being subjected to these crazy policies in their schools. like you said, SLF, we've been around for 50 years. We've been in this specific fight to save Title IX for years now. In our view, the fight to save America's schools is really the fight of our lives. It comes down to what kind of country we want to leave in our kids' hands. We say time and time again, this is not just a cultural war, it's a constitutional war. They're coming after our kids, they're coming after our Constitution, and we have to be vigilant. We have to be prepared. And so, what we were thinking of doing tonight is talking first a little bit about Title IX and the federal legal landscape, and then Corey can talk more about, how to fight back, especially at a state and local level in Wisconsin. So, that being said, I just have a few slides. So I'm going to share my screen. And here we go. Okay, so first of all, what is Title IX? We've all heard about it. We all are familiar with it, but it says that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. That is the full extent of the law as it was written in 1972. It is only 37 words. Okay. Congress passed the law in 1972 to essentially make sure that schools who are receiving federal funding do not discriminate or treat people differently on the basis of sex. Now, I want to take a minute here to recap separation of powers, something that we all hopefully learned in our civics lessons. Not sure if students are still learning it today. Unfortunately, that's, a fight for another day. But per separation of powers, the legislative branch, of course, creates the laws. The judicial branch interprets the laws. The executive branch has the authority to enforce the laws. Well, what happens when Congress passes a 37-word statute like Title IX, and there are some questions that remain, and the executive branch doesn't necessarily know how to enforce it in every situation? When those situations arise, the executive branch is allowed to sometimes come up with its own interpretations of the law and create rules that apply that interpretation. But when the executive branch or executive agencies are doing that, they have to be consistent with congressional intent. And this is where Title IX is going to come in. I just want to add too that these regulations can be formal or informal, or these interpretations can be formal or informal. So a formal interpretation is known as a regulation. And so this is what happens when an executive agency says, the law that Congress passed is a little unclear in this specific area. We are going to put out a rule, and we want to have people give public comments. They let the American people speak out about this rule, whether they think it's a good idea or a bad idea, before the rule goes into effect. It's called notice and comment. There's a whole process to it. Then after they go through this whole process, the rule becomes formal and it becomes binding. There's also an informal process where an agency can just put out guidance saying, hey, this is what we think Congress meant. We're not totally sure, but this is what we're going with. When they put out that informal guidance, it's not binding. It's supposed to just be helpful. So sometimes the Department of Education has issued formal rules interpreting Title IX. Sometimes it has issued informal rules. So to give a brief recap over the years, 1972 is when the law was passed. Again, only 37 words, lots of schools around the country. There's going to be some confusion, right? So in 1975, there was a lot of confusion among schools about whether Title IX extended to sports. And so because the law was unclear, the Department of Education was in charge of enforcement, and it released formal regulations saying, hey, we think that Title IX does extend to sports. So if you have a men's basketball team on campus, you have to allow women to form a basketball team and vice versa. Several years passed by, things were going pretty well. Congress passed another law in 1988 called the Civil Rights Restoration Act, where it clarified a few more things that had come up that were sources of confusion. And basically with that act, Congress made it clear that Title IX is meant to be very broad. So you can't discriminate against women or men in any sort of extracurricular activity when creating sports on campus, in campus facilities, in activities that are going on. And so this law, this Civil Rights Restoration Act, following up on Title IX, required equality by making sure that if any school had a boys' bathroom, it also had a girls' bathroom. But when doing that, it also allowed certain activities to remain sex separate. So it carved out specific things. For example, fraternities and sororities, mother-son, father-daughter events, living spaces like dorm rooms. They're all listed in that statute as things that can be kept sex separate. So by 1988, two things were very clear. Number one, Congress recognized that sex meant biological male or female because they were referencing mother-son, father-daughter, sex-separate facilities, right? And number two, Congress recognized that men and women are entitled to sex separation in private spaces. They are entitled to have separate bathrooms, separate locker rooms, separate dorm rooms. But then starting in the 90s, the Department of Education under Clinton started to kind of push its limits. It started expanding Title IX beyond congressional intent. Remember, the Department of Education can interpret rules, but only if they're following congressional intent. And I won't get too far into the legal weeds here, but for purposes of today, the important thing to note is that up until 2020, all of those expansions from the Clinton Department of Education onwards were informal. They were just guidance letters, dear colleague letters you may have heard of. But in 2020, President Trump put out a formal rule clarifying some Title IX protections. This was especially needed because there was a lot of confusion about due process. A lot of students were being falsely accused of things like sexual assault, sexual harassment. And so in 2020, the Trump Department of Education said, we're going to clear some things up and we're going to make sure that there are equal rights for accusers and the accused. Then in 2024, just 4 years later, President Biden put out another rule, a new rule that pretty much reversed everything that Trump had done in 2020. And most shockingly and appallingly, he changed the definition of sex under Title IX to mean gender identity. Okay, so going back to separation of powers, this is a big problem because in that original 37-word statute, sex is one of the key words. It is the defining feature of the statute, right? And Congress made it very clear that for all these years, sex meant biological male or female. So there's no real room for interpretation on this. It's not something that was left unclear for the Department of Education to clean up. Congress had very clear intent that it meant biological male or female. And President Biden said, I don't care. And he acted outside of the scope of his powers as the executive. So there were a few key changes that I want to highlight between the Biden rule and the Trump 2020 rule, which is now our current rule again. And I'll kind of get to that, the legal landscape in just a second. So for starters, the slides that say correct standard or correct definition, when I say that, I'm referring to what we believe is correct. We at SLF, I can probably speak for the folks at Will because they're on the same page as us, folks at Moms for Liberty. What all of us believe is correct and what many courts have said is the correct standard. But I just want to clarify that until the Supreme Court or Congress comes out and clarifies some of this stuff, we won't really have true uniformity. We won't really have a correct standard. So under the Biden rule, prior to the Biden rule, I should say, sex meant biological male or female, right? It was very clear. Title IX referred to boys and girls. All of the Department of Education's formal rules referred to both sexes or one sex or the other sex. Under President Biden, it became gender identity. So in other words, you can't discriminate against somebody based on how they identify. How do you know if you are discriminating against someone based on how they identify? You can't, right? It's totally subjective. And so this was a huge issue, not only from a separation of powers perspective, but just from a compliance perspective. Another key change that happened was, again, without getting too far into the legal weeds, up until Biden took office, it was widely understood that you can't harass somebody on school grounds, which meant that you couldn't create an unwelcome, you couldn't engage in unwelcome conduct that a reasonable person would say is so severe, pervasive, and objectively offensive that it essentially stops somebody from being able to go to school. So it would have to be something that everyone collectively agrees is really bad. It's a really mean, nasty thing for you to say or do, and you're doing it a lot. It's pervasive. You're doing it all the time to the point where somebody can't receive an education. The Biden standard was very different. It lowered the standard for harassment a lot. It became unwelcome sex-based conduct that is subjectively and objectively offensive and is severe or pervasive, that it limits or denies a person's ability to participate. So now you're taking things from the complainant's point of view, this subjective standard, and something that you say or do only had to be severe or pervasive. It didn't have to be both. So it could be a one-time statement that was maybe really mean, but you only said it one time. Or it could be a statement that wasn't really mean, but you did it a lot, such as misgendering someone, using their correct biological pronouns that they don't want to identify with. If you misgender someone on more than one occasion, that could potentially be considered harassment. It created all sorts of free speech issues here. Another thing that's not in this slide, but I just want to mention is that the Biden administration undid a lot of President Trump's due process protections. So there had been, as I mentioned earlier, a lot of confusion over the years about the rights that accusers versus the accused have when it comes to sexual assault, sexual harassment. And President Trump cleared a lot of that stuff up by making sure that students who were accused of sexual assault or harassment could face their accuser. They could call witnesses. They essentially had the right to a fair trial. Biden erased all of those protections, and he put all of the power in the hands of one administrator to decide if sexual assault or harassment or discrimination occurred. So one person got to do the full investigation and dole out a punishment to students. So that was also a really big deal and a really big problem. Now, something that is especially important and relevant to today's discussion is the sex separation piece. So up until now, Congress by law had said that certain spaces could be sex separate, as I mentioned. And with congressional laws, it was very clear that Congress was thinking men and women. There was no mention of fluid genders, no such thing as fluid genders in 1972. And in fact, some members of Congress have tried to pass laws in recent years, changing the definition of sex under Title IX to include gender identity, and they've more or less been laughed out of office. That has not gotten them very far. So it has always meant men or women. But under Biden, schools had to let students, and actually anyone, use whatever facility they identified with. So they expanded it beyond students to anyone who was on campus, visiting campus, which meant that grown men could walk into little girls' bathrooms. They could be just visiting for an away football game, and they could walk into a little girl's bathroom, and the school could do nothing to stop them. So, needless to say, many people sued the Biden administration, and we were one of those groups. We were fortunate to represent Moms for Liberty and Young America's Foundation in a lawsuit in Kansas in federal court. And we secured the nation's broadest and farthest reaching preliminary injunction against Biden's rule. So essentially, we stopped the federal government from enforcing this bad rule in any school where Moms for Liberty members had children or where YAF had student members. So that meant that it reached schools in all 50 states, which was huge. And since then, a federal court in Kentucky issued a final ruling on the merits of the rule. So in other words, essentially saying that the rule was unconstitutional, and it vacated the rule. And that means that it basically meant the rule never existed. And that holding from Kentucky applied in all 50 states. So again, another huge win. Now, the Biden Department of Education, of course, didn't like the rulings from our courts. There were other federal courts who issued rulings. So they did appeal some of those rulings to the Supreme Court. The Supreme Court allowed lower court decisions to remain in place, but it didn't weigh in on the merits. So in other words, the Supreme Court never weighed in on, yes, Title IX includes biological sex, and it doesn't include gender identity. They didn't go that far. They just said, we're going to let this play out among the lower courts. Of course, President Trump gets elected. His Department of Education says, we're not fighting these lawsuits, right? We agree with these people. This rule is unlawful. So it stopped appealing these rulings. Why am I saying all of this? There are still groups out there who support radical gender ideology. They support changing the definition of sex to mean gender identity, and they are trying their best to keep these lawsuits alive, right? They are asking courts to intervene. They want to step in and defend the rule when the federal government won't defend it. And so there are courts across the country who are facing issues with interveners saying, we want to be able to carry this case on. And so even though we have some really solid initial rulings, we may see some later appeals of those rulings if those interveners are allowed to come in and keep this fight going. So that being said, it's really important that we maintain our Moms for Liberty lawsuit because it keeps that preliminary injunction going that stopped the Biden Title IX rule, and it stops it from going into effect in any school where there is a YAF member or a child of a Moms for Liberty member. Okay, so I'm just saying all of that because I know there are probably a lot of Moms for Liberty members on this call who might have questions about where we are with this. We are still representing you in this lawsuit because we don't want to see an appeal happen where this rule could somehow come back into effect. There were some other big wins, of course. President Trump took office, signed some executive orders defining sex as biological sex, rejecting gender identity, protecting women's sports. There were some recent Supreme Court wins and oral arguments. Scarlett already mentioned Mirabelli v. Bonta. That was where schools in California were hiding gender transitions because they had to under state law. And like Scarlett said, the Supreme Court said, these policies are probably unconstitutional because you're interfering with parental rights. It's going back down to the state courts to play out, or the federal courts within California to play out, and we'll see, you know, where things go from there. There were also some recent arguments in West Virginia v. PPJ and Little v. Hecox. Those were two Supreme Court cases about whether states can ban boys from competing in girls' sports. We are likely going to see a ruling this summer, and we'll see how that plays out. Some other recent wins I just want to highlight on the federal level. Just in the last few days, the Equal Employment Opportunity Commission, EEOC, issued a bathroom ruling saying that federal employers can keep their bathrooms and locker rooms sex separate. That's also a huge win. We've seen plenty of state laws banning boys from using girls' bathrooms. So all of these things are amazing, and they confirm this right to privacy in sex separate spaces. They protect parental rights, they protect students' rights. But we still need either Congress or the Supreme Court to weigh in on the ultimate question for these victories to be long-lasting. And that ultimate question is, how do we define sex under Title IX? Does it include gender identity, or is it limited to biological males and females? And until the Supreme Court either issues a binding decision or Congress updates the language of Title IX, establishing that very basic premise, we're not going to have the uniformity we need as a nation. So until then, we're going to have to keep up the fight at the state and local level. We are seeing so many schools, so many states resisting federal law and federal court orders. And so we're going to have to keep up this fight. We're going to have to take it to the local level. And so I will pause there and kick it to Corey to kind of take it from here as far as Wisconsin goes.
Can I just ask one question real fast about Mirabelli?
Yeah, go for it.
That for Mirabelli, was there, from what I understand, there was something interesting in the change of standing, and that the court said that in order to bring to bring a case that a parent didn't have to have a child that was actually harmed by the policy. The child just needed to be in a school district where the policy, i.e. the secret transitioning of a child, was taking place.
Yeah,
Yeah,
do you want to take this one, Cece,
yeah,
or
yeah,
do you
go
want?
for it, Corey.
Yeah, that has been a massive issue. Will litigated a case against the Eau Claire School District where a parent association challenged one of those gender secrecy policies. And that was their argument, is that of course we have standing. This policy is in our school district where the children attend. If my child was suffering from gender dysphoria, I wouldn't know. I wouldn't even be able to say so because it's being kept secret from me, right? And actually, we were one vote short from getting the United States Supreme Court to take that case. But yes, in Mirabelli, the court, so what it essentially did was it was keeping in place a district court injunction against the policy to allow that injunction against the policy to remain in effect while the litigation continues. And part of the decision says the parents protected by the injunction very likely have standing because they are objects of the challenged exclusion policies. That's big. That's a
Yeah.
big deal. Yeah.
Yeah, that's a really big deal because often it's like the issue isn't ripe or you don't. I know a lot of the cases in which we there's parents and families that they're complaining about a policy because they're worried, but because they weren't directly affected, then they can't be a party to a case. So it's a big difference if there's an egregious policy and all the parents who don't want to send their kids to a school where that policy exists because they feel it's unconstitutional, that they have a right of action.
Yeah, yeah, that's what we were seeing. It's like, well, does your child have gender dysphoria? I don't know because the policy says that should be kept a secret from me. And the only way to not be subject to the policy is to leave the school. These parents tried to opt out and they weren't able to. So, that
And
that's
there
that's going to be significant, I think. And I on Mirabelli, before we dive back into the Title IX gender identity issue, I'll mention this at the end, and maybe we can send out an email after the fact with a few links. But we put out some school district guidance and parent guidance on what that decision did, and we also have an opt-out form. So if your school has a gender secrecy policy, or even if you're not sure if it does, opt out. Just opt out and make sure you're on record opting out as a parent so that you're not kept in the dark.
because it went so far as that they weren't providing parents accurate medical records, and they're basically um, they weren't following FERPA because they would keep two sets of medical records and they'd give parents one set and then there'd be another set where they were calling the kid by a different name, using different pronouns, and so that's just horrible.
Yeah, yeah, I agree. I want to mention too, as Cece was giving her overview, it reminded me that we did a very substantial resource with Southeastern Legal and the Defense of Freedom Institute. We'll include that link as well. It's called Protecting Title IX, a resource guide for school boards. So this is actually from November of 2024. So um, however, it includes what are federal regulations, background of Title IX, how is Title IX implemented. So if you want to go back and look at any of this, in addition to what like we said, we're recording this, but we have that resource for school boards as well. And even though it was before the Biden Title IX rule was enjoined, I think it's still helpful because, as Cece mentioned, we're still fighting these bad policies. So.
Yeah, and thanks for bringing that up because we also have we've had Title IX resources that we've put out and we've had to update a few times and keep reprinting them and resending them out because the landscape changes so often. So I'm glad you mentioned that. So let's definitely link those resources for people at the end.
It's my favorite resource, by the way, and it's still relevant right now because you have so much background information. And a lot of parents, like the ones in New Richmond, it was a whole brand new issue to them and they needed that whole background or they needed all that information. So thank you.
Yes, I'm glad. I'm glad. Before I start my section, that's a little bit more Wisconsin or Seventh Circuit specific. I just want to mention too, I know one of you found the Q&A function, but at any time, if there's something that you want to clarify or if you have any follow-up questions, feel free to put questions in there. There should be something that says Q&A. So, okay, with that, I'm going to dive back in. I do not have slides. I'm just going to talk. And I'm going to talk a little bit about Wisconsin and what is the state of litigation. It is a little bit complicated, of course. Some of the foundational pieces to understand involve that. One of the Q&As said, what about Whitaker? And that's what we hear a lot here in the Seventh Circuit and here in Wisconsin. Whitaker, Whitaker, Whitaker. This is the law of the land. What about it? And I think it's important to understand that case and what it did and what it didn't do. So, of course, as we had mentioned, there are 3 levels to the court system, the federal court system in this instance. You have your district court, the courts of appeals, and then the United States Supreme Court. So the Seventh Circuit, which includes Wisconsin, Illinois, and Indiana, in 2017, it issued a decision in Whitaker. This was a lawsuit filed against the school district in Kenosha, Wisconsin. You've probably heard about this case. We get asked about it a lot. It was a case brought by a transgender student who was a girl who identified as a boy, she wanted access to the boys' bathroom, the opposite sex bathroom. That student won their case. That student won at the district court. The case got appealed to the Seventh Circuit, and the student again won at the Seventh Circuit. And the takeaway from the decision was that the school district had to allow that particular student to use the bathrooms of the opposite sex. Unfortunately, though, there's a lot of misinformation or incomplete information out there about what the case said and what it means, and that is what I want to explain this evening. So in a typical case, you file the complaint and then each side gets to do discovery, put together their evidence, and the whole process takes from 6 months to a year, if not longer, before you eventually get a final ruling from the district court. But there is a way to abbreviate that process. It's not uncommon, and if a plaintiff thinks they need immediate relief, they can move for what's called an injunction. That is what happened in the Whitaker case. So the student filed their complaint, moved for an injunction, and asked for an order right at the start of the litigation, asking the court to immediately say, I get access to the opposite sex bathroom. Okay, the student won that injunction, and the district court, the school district, immediately appealed. So that's the posture that got this case up to the Seventh Circuit Court of Appeals. And that posture is relevant because the school district and their attorneys didn't have the opportunity to put forth a full record like they typically would. So the Seventh Circuit was analyzing just the facts that it had before it. So one of the criteria for an injunction, and this is really important, is the student likely to succeed ultimately? We're not there yet, but do we think this student is going to succeed what's called on the merits? That's where you get the language from in the decision. Yes, the student is likely to succeed. There's language in there suggesting the Seventh Circuit thought that Title IX requires school districts to allow transgender students to use whatever bathroom they identify with. So importantly, the Seventh Circuit in that case said, yes, we think Title IX probably does require the school district to allow this student to use the opposite sex bathroom. Now, we at Will, and we've said this before, we think this case was wrongly decided. We think Whitaker was wrongly decided. We think it's a misinterpretation of Title IX, but that's what the Seventh Circuit said, and that is a binding decision on lower courts, so district courts in the Seventh Circuit, and it has been since 2017. Now, since Whitaker was decided, other federal courts of appeals have weighed in on the issue, most notably the 11th Circuit, which covers Alabama, Georgia, and Florida. They went exactly the other way. They said very clearly, we think Title IX does allow school districts to limit bathroom use by biological sex. So now we have what is called a circuit split. Different circuits disagree on this legal question. And here again, as Cece was mentioning, eventually the United States Supreme Court will have to weigh in. We think that the reasoning in the 11th Circuit undermines the Seventh Circuit decision in Whitaker a little bit. And one of the other things to know about Whitaker is because it went up on this preliminary posture, it wasn't even a final decision in that particular case, nor did the language in the case make it so universal to say that in every situation with every student ever, school districts always have to allow a student who asserts a transgender identity to use the opposite sex bathroom. The Seventh Circuit was only considering the particular case before it. There are a lot of things that could matter. The age of the students, the distance the student had to walk to use a neutral alternative bathroom in the school, how well documented is the gender dysphoria, and things along those lines. And this is the kind of things that lawyers do all the time in cases, future cases with similar facts and similar legal issues, is trying to distinguish prior cases, comparing that new case to the prior case and say, maybe our bathrooms are closer, the students are younger, or whatever it might be. And since the Whitaker case in 2017, there have been a number of cases where school districts have attempted to distinguish Whitaker in similar factual scenarios involving bathroom use by transgender students, and even involving a similar basic procedural posture, saying we think our case is different for X, Y, or Z reason. And I think there are probably about 5 or 6 of these cases, there could be more in the Seventh Circuit, where school districts have tried to distinguish Whitaker. But in every one of those, so far, the school district has lost. One of those cases even went back up to the Seventh Circuit recently, AC versus Martinsville. That's the initials AC. And the school district had a lot of arguments for why they thought that the outcome should be different. They lost at the Seventh Circuit, but they did get one vote. So when you have an appeal on the Seventh Circuit, there's a pool of judges and you get 3 randomly. And as you can imagine, different judges disagree about reasoning sometimes. But the court ultimately said, we're going to stick with our prior decision in Whitaker. We think Title IX requires school districts to allow transgender students to use the bathroom they identify with. One of the judges said, I think Whitaker was wrongly decided, but I think this is an issue that the US Supreme Court will eventually have to weigh in on. So the school district in that case tried to get the US Supreme Court, tried to get the case there, asked them to take the case, and many people thought that they would. We have this circuit split with the 7th and 11th circuits coming to opposite outcomes here, but the US Supreme Court did not take the case. They denied review of the case. So what that means is, for the time being, for any school district in the 7th Circuit, again, Illinois, Indiana, Wisconsin, Whitaker, and AC are the binding precedents on trial courts, which I use synonymously with district courts, that first level. So if a school district has a policy that says we're going to limit bathrooms based on biological sex, and a transgender student sues the school district over that and says they want access to the opposite sex bathroom, the trial court actually has to look at Whitaker and AC and say, I'm bound by the 7th Circuit. And they have and said Title IX requires this. That's what the 7th Circuit has said so far. Okay, so that's not great news so far if you're looking to separate bathrooms by sex in Wisconsin or elsewhere in the 7th Circuit. But that's just what it is for the time being.
I have some questions when you.
Yeah. Do you want to chime in now?
Sure. Yeah.
I'm
So,
getting to the good news.
okay, good, because that's like really depressing.
Go ahead.
But so the McGuanago case, are you getting to that?
Yes.
Yeah. Okay. All right. So that and then so the federal government is investigating the new Richmond School District claim under the auspices that there is a potential Title IX violation because they are not allowing the girls to have their own safe space. There's not a sex separated bathroom, and then that would be a Title IX discrimination. So the federal government feels that that Title IX means that sex is male, female, and that there should be sex separated spaces. So how does that balance?
Yeah, that really good questions. I am now, this was like perfect timing because I'm turning now to why, you know, school districts or parents you might hear, oh, we're bound by Whitaker. Our hands are tied. This is the law. We can't do anything. Okay. That's actually not accurate, even considering everything that I just went over. We don't think that's accurate at all. One thing to understand first is that Whitaker and AC are only about bathrooms. That is the only issue in those cases that was presented to the court. There's nothing about locker rooms, changing facilities, anything other than bathrooms. So that's one thing. The other thing in Whitaker is there was nothing in that record, the court record, from the other students or their parents. So other students saying, "Hey, I'm uncomfortable with a student of the opposite sex in my bathroom." There wasn't anything in the record, and the court actually noted that. They said, "We don't have anything in the record to say whether this is impacting the other sex." And as we will talk about in the next couple of minutes, that is very different from what's happening in New Richmond, Wisconsin. Even in Elkhorn, Wisconsin, where we represent a parent association on this issue. Another thing, and I don't want to get too into the weeds in this, but it's really important and it ties back to what Cece was explaining about the Title IX litigation. One of the cases that were challenging that Biden Title IX rule already went up to the US Supreme Court on a motions posture. Basically, the federal government under Biden went up to the US Supreme Court, asked for the scope of the injunction to be limited. And the US Supreme Court denied that. It was a 5-4 decision. But notably, all 9 justices agreed that the bathroom portion of the Biden rule should be enjoined. So that is not binding precedent, but is a very strong signal on how that issue will ultimately potentially turn out when it does reach the US Supreme Court. Didn't overrule Whitaker, but honestly, it undermines Whitaker and is a signal that Whitaker is on thin ice and not likely to be precedential in the future, in our opinion. The other thing, Scarlett, you brought up the McWanago case. This is a very similar factual scenario. The school district wanted to separate bathrooms by sex, and there was a transgender student that wanted to use the opposite sex bathroom. Initially, the student in that case won again on the preliminary injunction. It was appealed, student won again. Okay, so as that's happening, or shortly after that happens, the United States Supreme Court issued a decision in a case called Scrimeti. Now, this is a case, if anyone was following it, involving the medical transitions of minor children and whether states can ban that treatment. And the US Supreme Court ultimately said, yes, states can make that decision. There's no violation there. Okay, so we have Scrimeti decided, and shortly afterwards, the Seventh Circuit, on its own, without being prompted or asked by any of the parties, vacated their decision in the McWanago case, and they granted what's called a panel rehearing, and they wanted to consider whether, they explicitly asked this, I'm reading from their docket right now, consider whether the court should overrule Whitaker versus Kenosha Unified School District and AC versus Metropolitan School District of Martinsville in light of Scrimeti. So they asked for more briefing. They also wanted the parties to address whether, if the court overrules Whitaker and Martinsville, is the challenge policy still valid in light of Scrimeti? The school, okay, so that's significant. The Seventh Circuit on its own, after the Scrimeti decision, said, oh, we're vacating our decision here. Should Whitaker and AC be overruled? We want more briefing. We want to rethink about this now with this new United States Supreme Court precedent. That happened in June of 2025. The school district filed its brief in July of 2025. In August of 2025, the plaintiff, so the transgender student in the McQuanago case, moved to dismiss the appeal. So that case was dismissed. The school district opposed that motion. They didn't think it should have been dismissed, but nonetheless, it was dismissed. So we still have Whitaker. It wasn't overruled yet. That's I think the important things to know about the state of the law in the Seventh Circuit. There's a lot going on here. I have a few other notes here, but any questions about bathrooms or the related case law?
I don't know if there's any in the chat, but so they moved to dismiss the appeal. I mean, that seems like they did that because they thought they could lose. They thought it very likely they would
Their
lose.
argument was that it was moot. They said the appeal was moot. But I've heard that before, that others have said there's like a thought of, oh no, we're going to lose and get this really good case overruled. We don't
Yeah.
want this.
Didn't that happen? Wasn't that one of the two cases that SCOTUS just heard in January? They tried to back out, and I mean, it seems to me, and I can say this, I'm not a lawyer, but it seemed to me that they were trying to back out because the precedent that was going to be set wasn't going to be in their favor.
Yes, one of the girls' sports cases. Yes. So, all right, we got about 15 minutes left. I just want to mention a few things briefly. Another thing we have that undermines Whitaker, in my opinion, or maybe gives some force to the arguments against Whitaker, would be the better way to frame it, is the Trump executive orders. There was one on day one. It was language related, defines a man and a woman, directed agencies on how to interpret sex as man and woman. No federal funding spent to promote gender ideology. There was another executive order on ending teaching gender ideology in K-12. Another one explicitly about keeping men out of women's sports. And there was a direction to the executive agencies under Trump to bring Title IX actions against districts that allow men and women's sports. And we're seeing right now a Title IX action in New Richmond about a district allowing a boy into a girl's bathroom. So one more thing, because I think this is related, but not exactly an issue in the federal litigation. It's just something that comes up a lot, is that districts say, we're bound by state and federal law. This is the state and federal law. I encourage parents and school board members to say, which law can you cite? Is it a statute? Is it a court decision? What are you talking about? Okay, so I've yet to find out, but if it is the state statute on student non-discrimination, I just want to point out that the Wisconsin law, state law on student non-discrimination, doesn't actually include gender identity at all. It bans discrimination on the basis of sex, race, religion, national origin, ancestry, creed, pregnancy, marital or parental status, sexual orientation, or physical, mental, emotional, or learning disability. It's a lot of things, but it's not gender identity. So just something to be aware of as well. Scarlett, do you want to talk a little bit about New Richmond before we wrap?
Well,
Or
I was
anything
just
else?
in New Richmond yesterday. It was great. It was a great event. So we've been talking about case law, about constitutional law, and one thing I want to bring up is that there are elections in Wisconsin. There are school board elections, and sometimes the legal process, as we could see, takes a long time. And ultimately, we need to keep up the pressure. I highly encourage parents, whether you're in Wisconsin or any other state in this country, that if there is a policy where there are boys in your daughter's bathroom, shower room, locker room, to please contact either one of these lawyers or their firm, Southeastern Legal Foundation or the Wisconsin Institute for Law and Liberty, because you may have a case. At the very least, you can organize and contact Moms for Liberty, and we certainly can help you to organize and fight back. You should not just accept when they say, oh, our hands are tied, this is just the way it is. Absolutely not. We've had some setbacks, but we've had a lot of wins, especially lately. And I think we have the wind in our backs on this issue. Something that was very special about New Richmond was that there were girls, teenage girls, 16-year-old girls, 14, 15, 16-year-old girls that stood up, went to the school board meeting, and they said no. They said, we don't like this. We don't want this. We feel that you're not listening to us. We don't have privacy. We want protection. Please protect us. So they spoke out. And not only was that visual storytelling important and impactful and led to this story of a very small rural town in Wisconsin to go viral, right? Just today, I mean, there's millions of views of one of the girls in question, Ella, who's 16, who she just made little videos talking about how she felt about this policy and what was happening to the girls in her school district. So please speak up, please speak out if you're, with your parents' permission and with their support. It makes a world of difference. And because of the parents, because of the girls speaking out, there was very swift action by the Trump administration and the Office of Civil Rights. And so I just, please contact Moms for Liberty, contact Will, contact Southeastern Legal Foundation if a policy like this is happening in your school district. But there's another very, very important way that you can make change, and that is to vote for a different school board. Run for school board, work for people who are running for school board. And when there's an election, make sure you ask the simple question of the person who's running. Can men get pregnant? Just ask them that. The answer to that question should help determine who you vote for. Would you put a boy in a girl's locker room? That should help you answer that question. And in Wisconsin, early voting starts March 24th. And our election day for nonpartisan elections is April 7th. So please look. We have a list of candidates that we endorse at Moms for Liberty. And so please check out or ask questions of those running for school board and vote for common sense. Vote for someone who has courage and a backbone and who will challenge, that they will be the person who will say, you know what, we're going to follow federal law. We are going to interpret Title IX to mean that the protections afforded by it are determined based on sex and not gender identity. So that's my feel. Please just get involved, vote, and fight back.
Yeah, I think you make a great point, Scarlett, that obviously we're here talking about Wisconsin and bathrooms tonight, and we were spurred by everything going on in New Richmond. But this is something that we are seeing play out across the country right now. We are seeing boys entering girls' bathrooms and locker rooms in red states, blue states, it doesn't matter. And we see girls then try to stand up and speak out against it. And sometimes they are successful and they're given a platform. Other times they're told to be quiet. They're told that they'll be punished if they speak out against these policies. And so there are these privacy concerns at play. There are these free speech concerns at play. There are parents being kept in the dark. It's a very layered situation going on right now. And so I think you've summed it up perfectly to get involved, be vigilant, run for office if you can, know what's in your students' policies, your school board policies, and definitely reach out to us if you have any questions. And I'll go ahead and drop our SLF resources here in the chat. And Corey, I'm sure you guys have some that you can share too. So I'll make sure I'll do that right now before I forget.
Yes, we'll gather all of those resources up. one of the resources that I didn't talk about that I want to flag is that we just recently, within the last month, released a model school board policy to separate bathrooms by sex. And it's 2 pages long. The policy itself is less than 2 pages long, but it includes a section on why adopt this and a couple paragraphs of a legal analysis. So we did this because even though Whitaker is not overruled, it's still the law in the Seventh Circuit. Um, for all the reasons that I kind of went over, we think it is probably on thin ice and wrongly decided. And I think it is a good thing for school board members to, of course, be prudent, understand the lay of the land when it comes to the legal background, of course, but know that there's risk on both sides. There's not only risk of being sued by the transgender student or, the student getting the ACLU or some other law firm to represent them and sue the school district. There is also a concern that parents of girls, they could file a Title IX action as well, whether it's federal complaint, whether it's a lawsuit, that's not out of the question. And what we're seeing in New Richmond is a perfect example of how this is a policy affecting not boys and girls, it's affecting girls. The girls are having to go stand in line in the hallway for the neutral bathroom. The girls are late to class. The girls are uncomfortable in their bathroom. It's only affecting girls. That is a big consideration under Title IX. So for all those reasons, we drafted this model school board policy. It's available for free at schoolboardpolicies.org. And I'll get the specific link as well so that we can share that. It did get brought up to the board in New Richmond. However, there were not enough school board members for it to go anywhere. But the parents they want this policy.
And it was mentioned in the press release that an alternative policy was presented and they rejected it. So I thought that was pretty cool.
Yeah, I mean, it would have been great to see that adopted, but I wasn't holding my breath, unfortunately. You know what? If we see more and more school districts interpreting Title IX in the way that we believe it was intended to be interpreted, and the way that the Trump administration is interpreting it, and you never know what a court's going to do. You never know. I'm not saying I know what's going to happen here, but there are a lot of signs pointing in the direction that Whitaker might not always be around. So.
Yeah, and I thought it was very interesting that in the complaint, in the press release by the Department of Education about this investigation with the Office of Civil Rights, that it was sort of laid out that parents found out there was harm, girls complained, parents sent emails, and they went and talked to the administrators and school board members. There was recorded school board meetings where they rejected the parents' claims. They didn't listen to the girls. There was emails showing that the administrators rejected that the girls said this is unfair. Why are we meant to feel uncomfortable? Why are we the only ones that don't have the privacy in the space? And then there was an alternative policy presented by one school board member. And then all of these things that the school district had done wrong. So I think it's important when you are fighting back to just be methodical, just keep your receipts, do everything in the right steps. And, thank goodness for both of your organizations, because you have taught us so much about how to do things the right way and to be thoughtful. And by doing so, you have a much higher likelihood of success. So thank you very much.
Yeah, thank you too for all your work, and thanks to the parents. I mean, be methodical, yes, but also be persistent and be willing to speak out, because it's not an easy thing to do, but worth it, in my opinion.
Yeah, and I think half the battle is just kind of uncovering the truth, not only what's happening in schools, but getting the public to believe that this is happening. I can't tell you how many people say, oh, that's not a real story. That's just clickbait. That's not something that actually happened. So like you said, Scarlett, have your receipts ready because you're going to be asked for them.
Mm-hmm. Mm-hmm.
always say when the thing that never happens happens. The
Yeah.
thing that never happens happens. Yeah, have your receipts, prove it, and then the community and will be by your side. I mean, this really is an 80-20 issue. I think it's really like a 90-10 issue, but it doesn't matter what political affiliation. Most people do not want to have boys in the girls' bathroom or in their private spaces. So
No, no, it's just common sense, but for now we're going to keep fighting. Okay, well, I don't see any more questions in the Q&A. People are welcome to reach out. I'll drop our email address as well in here. In case you have
I'm
any
not sure.
inquiries.
I don't think I'm able to. I see you're chatting to
Oh, you're not
everyone,
able
and I
to?
don't know
Okay.
how to do that.
Do you want
But
me to
that's
put your
okay.
address, Corey, or what's a good email
oh
address?
yeah, I should put mine as well, I guess. I'll put
Yes,
mine in the chat.
cbrewer@will-law.org is good for
Uh,
me. And then we can just compile all of these links into an email and
yeah.
get
Yeah,
those
we'll
to
send a
you.
follow-up email too.
And yeah, mine is really easy, Scarlett at moms4forliberty.org. And we have, and I'll include our list of resources for school board candidates and where you can find our endorsement page.
Okay. Awesome. Well, thank you both for being here tonight. Thank you everyone for joining us. It was a great conversation. I learned a lot from both of you actually, and really appreciate all of our collaborations together. So looking forward to the next one.
Thank you. Moms are going to save America.
Amen. All right. Good night, everyone. Thank you.
Good night.